that creation of the vacancy itself, not in the context of recruitment rule. So the other side's ballot, if I am for the other side, and if I have to refute my argument, I would say any vacancy, if it is created,
irrespective of when it did occur.
Yes, irrespective of whether recruitment process was initiated or not initiated. That, in my understanding, that would be the best argument. That I don't mind. The note says that I would take the English meaning of the word occurrence. So occurrence means the date of birth. I mean to say that when it is born. So any vacancy, if it is created 2015, this 50-50 will not apply. That would be the best argument against me. But then my answer to this argument would be, the substantive provision of 50-50 is for the post, meaning thereby this is the ceiling. No matter what is the number of vacancy, the substantive provisions of 50% for the directs and the 50% for the promotees cannot be tinkered with.
It has to be 50-50.
It has to be 50-50.
You are appearing for the
promotees.
The writ petitioners.
Like the writ petitioner.
Who is for the writ petitioners?
My lord, some of my other learned friends.
Well, 493, I am for the writ petitioner.
Yes, similar.
Yes, yes. Similar.
Yes. Page 51.
Yes. Lordship, may kindly see, this is the notification, that is the rule. Now, first, my lord, I would be placing that this rule is only for the purpose of recruitment. So therefore, if there is a recruitment, this rule is a relevant rule. Anything other than the recruitment, this rule has got nothing to do.
Yes.
For that, my lord, the first paragraph itself, in exercise of powers conferred by the proviso to Article 309 of the Constitution of India, and in supersession of all the previous rules on the subject, the governor is pleased hereby to make the following rules regulating the recruitment to the post of supervisor of Integrated Child Development Services Scheme. So therefore, I am on rules regulating the recruitment to the post of supervisor. Thereafter, my lord, kindly take the second paragraph. The method of and the qualification required for recruitment to the post. My lord, I am only on these two words, for recruitment to the post. So the method under the rule prescribed, it's not a method for anything other than for recruitment. Second paragraph, first line, the words for recruitment. Now, my lord, rule 3, method of recruitment. By direct recruitment, 50% of the posts. Well, I am not reading others. Now, lordship may kindly see the words posts as different from the words deliberately not being used, vacancy. So direct recruitment is 50% of the posts, and promotion out of remaining 50% of the post of supervisors. There is a 45-5, but that is not relevant here. So my submission is that the rule is exclusively for recruitment. Method of the recruitment says 50% post for the direct recruitment and remaining 50% for the promotion. Now, my lord, the note, which apparently looks like as if it is against us, but I might be able to persuade your lordship that this is not against us at all. Note, in case of vacancies, lordship may kindly mark the word occurred up to 30th September 2015. I'm not reading rest because then they say it's 75-25. My submission before your lordship is this: the word occurrence has to be understood in the context of a recruitment, which is the purpose of the rule. In other words, existence of vacancy
Yes.
is not occurring of the vacancy for recruitment.
Hmm.
Now, there is a direct judgment by a full bench judgment of our court on that. 2019 SCC Online, Calcutta, 381. There, your lordships, Justice Dotto and Justice Saraf, first your lordship's view, it was again 2019 SCC Online, Calcutta.
Recruitment and selection are different.
Yes. And then their words, first it was your lordships, then it was endorsed by Justice Dotto, and it was exactly echoed by Justice Saraf.
Maybe mine was not strong enough to stand that.
But then it was scrutinized by Justice Dotto and Justice Saraf. Well, paragraph 38. This is your lordship's words. Kodamtala High Madrasa.
Yes.
Paragraph 38. The term selection means exercise of discretion of the members in the selection committee in examining the participants. The candidature of the aspirant cannot be construed to have been considered on the date of creation of the vacancy or on the date of issuance of prior permission, since the said two dates are prior to invitation to participate in the interview. The selection process cannot be construed to have commenced on the said dates. It is only on the date of advertisement, when the candidates are invited to apply. The selection process commences and the fourth issue is accordingly answered. Lordship may kindly take paragraph 42, Justice Dotto. I am in complete agreement with the learned Advocate General that although ordinarily the words recruitment process and selection process are used interchangeably, the same are not synonymous. Paragraph 42.
Yes.
I am in complete agreement with the learned Advocate General that although ordinarily the words recruitment process and selection process are used interchangeably, the same are not synonymous. By and large, a selection process is an integral part of a recruitment process that an employer initiates to fill up vacancies by open selection. While recruitment process starts with the decision to fill up, and I am on decision to fill up an identified number of vacancies in the manner prescribed, and ends with appointments in favor of the selected candidates. A selection process could commence with a requisition of names of eligible candidates from the relevant employment exchanges and the issuance of a public advertisement, or even thereafter, depending upon the language of the governing rules. And normally, a selection process would terminate with preparations of the final panel merit list. Now, 47 is Justice Saraf's. Question number, paragraph 47. It is paragraph 46, last paragraph. This should be, my lord, page number 13. The pagination is very difficult to read. Last paragraph. D, question number 4. As to when a selection process is commenced, whether with the arising of vacancy due to the death, resignations, or retirement of the incumbent to the said post, or with the creation of new post, or when the post is advertised and candidates have been called for interview, or after the interview is held. Answer: the selection process would commence only after the advertisement asking candidates to apply for a particular post. Now, Lordship may kindly come back to page 51 of the rule. But this is a full bench judgment.
Yes.
Now, my lord,
You formulate your
yes,
formulate
yes. My first formulation is a note in a statute cannot control or override the substantive provision of the statute. That's my first formulation.
Yes.
For that, I say, if I can say thereafter, I show.
Yes.
I say that the legislatures wanted this so well. That's why they have used 50% in respect of a post. So therefore, if there is a cadre, in this case, there are 4,000 and odd, I think 4,900 and something. That's the total number. So legislatures wanted that I am creating a rule by which the 50% of the total number of posts should be for the direct recruitees, and the remaining 50% should be for the promotees. This is a substantive provisions of the statute itself. Now the note says, if I read
of vacancies.
Yes, note says in case.
What is your argument?
Yes, my argument is, note says in case of occurring of the vacancy, meaning thereby in case the occurring in the context of recruitment process starts, vacancy arose 2015 should go by 75/24. Number one.
So occurrence has to be
in the context of the first paragraph of the rule itself. Under Article 309, this rule is for recruitment to the post. It's not addressing the existence of the vacancy. And your lordships in the full bench have clarified it when it commences.
So the vacancies have to be in the context of the recruitment as per the rules.
Yes.
So that that answer will negate what? What is the other side of the coin?
The other side of the coin would be what my learned friends would be saying, that creation of the vacancy itself, not in the context of recruitment rule. So the other side, if I am for the other side, and if I have to refute my argument, I would say any vacancy, if it is created,
irrespective of when it did occur.
Yes, irrespective of whether recruitment process was initiated or not initiated. That, in my understanding, that would be the best argument. That I don't mind. The note says that I would take the English meaning of the word occurrence. So occurrence means the date of birth. I mean to say that when it is born. So any vacancy, if it is created 2015, this 50-50 will not apply. That would be the best argument against me. But then my answer to this argument would be, the substantive provision of 50-50 is for the post, meaning thereby this is the ceiling. No matter what is the number of vacancy, the substantive provisions of 50% for the directs and the 50% for the promotees cannot be tinkered with.
It has to be 50-50.
It has to be 50-50. Because otherwise, I would show that otherwise this two things, the word post would not have been used. And number
let us read the note. Note says that in case of vacancies occurred up to 30th September 95. So what is
2015?
What is your argument pertaining to the note?
My argument pertaining to the note is this, that the occurrence of the vacancy.
No, the note says that in case of.
No, first Lordship said this is a note of what?
Recruitment.
This is the note for a recruitment rule.
But let us read the total of.
Yes, yes, I'm reading total. Right. Correct. In case of vacancies occurred up to 30th September 2015, the ratio of direct recruitment as indicated in Rule 3A right? And recruitment from the category of Anganwadi worker and case workers, as indicated in 3B, taken together will be 75-25 ratio respectively. And in case of vacancies created thereafter, ratio of directed, but thereafter is already covered by substantive. So first part, if I make it in this simple way, note says, in case of occurrence of vacancy pre-2015, ratio should be 75-25. In case of post-2015 vacancy, it should be 50-50. That's the note says.
That is what the trial judge has also said.
No, trial judge has taken a view in our favor. Trial judge has said that it should be 50-50. So we are supporting the judgment of the learned single bench. Learned single bench has very correctly understood this and directed that it should be 50-50.
So post September 2015.
I say, I have the other points, but
so how that analogy matches with your argument? If you distinguish between recruitment and selection,
yes,
that will not match with the order, which goes in support of you, as you are saying.
Well, it matches in this way, like devil's.
You are saying that recruitment and selection are two different things,
right?
Recruitment as notified means recruitment itself,
yes,
irrespective of creation of vacancies. But note incorporates a rider to the effect of creation of vacancies.
Yes.
That you say has to be read with the recruitment.
In the context of a recruitment.
In the context of the
Now, why I say this? May I say this? But I would say both sides. Now, I don't, because it's a point of law. I'm
not being able to understand. Yes. The trial judge has said that it will be 50-50.
Right. So substantive provision.
Now 50-50 pertaining to which vacancies?
50-50 pertaining to the law says posts.
No, what does the trial judge say? Let us come to the judgment of the trial judge, Mr. Dhar.
Yes.
Was that portion? The trial judge.
But at 50-50, Lordship may kindly
say 50-50.
50-50.
Pertaining to which vacancies?
Well, 50 page.
Prior to September 2015, 75-25. Now it has been brought down.
May I say this? I think my answer I would be able to give better from Mr. Bandobada's chart itself. There is a clear-cut answer. Kindly take the chart at page 40.
Now, first, tell us now what is your interpretation of this direction. Page 62. Accordingly,
may I come to page 62?
The court has said 50% of the vacant posts of supervisors will be considered for promotion.
Lordship is at page 62. Which paragraph?
Penultimate paragraph.
Accordingly, this court directs that Anganwadi workers to be considered for promotion in respect of 50% of the vacant post of supervisors.
At what juncture?
The total, now that juncture is coming. The total number of which is 3458. Their chart will show that 3458. That number was brought in 2009 itself. So vacant
7th of March 2019 memo, which was challenged.
Yes.
So their court says 50% of the vacant post of supervisor, which the total number of which is such and such, will be handed over by the court by the state, will be for promotion. The
reason being, page 40 of their chart would clearly show. It was not shown before your lordship.
345 has occurred
in 2019 itself for the purpose of recruitment. May I go there directly?
Yes.
Because I was also surprised after reading that. Kindly take 40.
Page 40.
Yes, that's the chart what Mr. Bandobadda has relied on. Serial number 9 of the chart. When this number of posts were sanctioned, kindly take serial number 9. First I read number of supervisors sanctioned as in January 2019, 4958. Now, number of supervisor in posting, so those are working 1500.
Cutoff was 15 September 2015.
But cutoff was 15.
2015.
Yes. So all I am saying, there were existence of vacancy of about 3009, for which
where do you get that figure?
That figure can be found. Lordship may kindly see serial number 6. A mere existence of the vacancies for which never any recruitment process was taken at all. And that's why a sanctioning by the cabinet was taken in 2019 that we want to go for a recruitment for 4,958 number of vacancies. Once that is done in 2019, post rule, only logical corollary would be that half of 4,958, the half is, my lord, 2479.
No, but in the writ petition it was 3376.
That is, there are some other calculations.
Achha.
So lordship,
but 3376 is proper.
Yes.
3376 as per the notification. Now, when the advertisement was made, that was 3376.
But that I'll address when I show that. Before that, lordship, all what I'm trying to say, I say that by their own document.
We understood. Yes. By their own document, the number of vacancies existing as after September 2015 was this much. As such, it has to be 50s to 50. This is your
yes. And I say that serial number 9, the word sanctioned in January 2009, sanctioned. And serial number 10, supervisors who are already working. So 4,958 is the total cadre strength, if I can use that word, total number of posts, out of which 1,500 persons are already working, meaning thereby 4958 minus 1,500, the result is 3458. That is the creation of vacancy for the purpose of or in the context of a recruitment in 2019, which has got nothing to do with lying or existence of the vacancy in 2015.
Yes.
If I just, let's say, one more sentence on that. For any recruitment, first, my lord, there has to be a cabinet decisions, or it can be called to be a sanctioning. Yes, I may have 5,000, I as a state may have 5,000, 10,000 number of vacancies. But state has to take a decision that we want to go for a recruitment for X number of vacancy. My submission is, once that is done, then the context of recruitment comes. Had there been a case that before 2015, there was a notification for filling up, let us say, X number of vacancies, I can say by giving concession on a point of law, yes, by note, that may be reserved for 75-25 ratio pre-2015. But that situation does not and cannot arise because of serial number 9 of their own chart sanctioning of 4958 and existence of working is 1949. So 3009 is the, now is, if I use the statute spelled word, 3009 is the occurring of the vacancy in the context of the recruitment rule. So once that occurring of the vacancy in the context of the recruitment becomes 3009, half of the 3009 is for the direct, half of the 3009 is for the promotees. That's the rule addresses. Now, Lordship, I have said this, but I said that 2004 13 এসেছে এটা নোট পয়েন্ট 2004 তারপরে 2005 দুটো
Now, in the advertisement, how many vacancies did they notify?
Yes, Lordship, what we challenged, that would show that.
You challenged 7th of March 2019.
Yes, kindly see, we challenged page 31.
Page 31.
Yes. And that would also again show the cabinet decision. That's a very initiation of the recruitment process.
So the vacancies notified were there 38. Total vacancies that 3376.
Yes.
That is 422 plus 295.
Yes. Lordship, kindly take page 31.
So you have challenged this because this has been done in the ratio of 75-25.
Yes. And that I have calculated. Now, if it is to be followed, the ratio becomes, the promote is, if I can place it and then I give the calculation. Kindly take my page 31. It becomes 87.5% and 12.5%. Total violation of the rule itself.
80, from where you are getting 80?
Kindly come to page 31. Kindly take first paragraph, then I'm saying.
Yes.
I am directed to inform you that 55th meeting of cabinet held on 21st February 2019 has approved VD number such and such, Roman 1, recruitment rule for the post of supervisors under ICDS.
That is
that's a sanctioning.
That 25th February.
Right, yes. And Roman 2, filling up of vacancies of, this is the 3376 post of supervisors on the newly framed recruitment rule, of which 422, now Lordship may kindly mark, this 420 numbers post will be filled up by promotion, that becomes only 12.5%. By selection from Anganwadi workers under ICDS, case workers under control vagrancy, the remaining 2,954, that becomes 87.5%. So in 2019, cabinet is approving. 2019, it is post.
This is not 75-25.
No. This is a complete fallacy.
This is 422.
422 equals to 12.5%. It is 422 divided by 3376 multiplied by 100.
2954.
It is 2954 divided by 3376 multiplied by 100, 87.5.
So these also do not tally with their
substantive provision. Yes. Lordship may kindly see if the
না সেটা তো এখানে স্পেসিফাই করছে না, এখানে শুধু নোটে বলে কোন ব্যক্তি
ওই হিসেব থেকে হিসেবে সার্জেন থেকে হিসেবটা ক্লিয়ার সেই চার্ট Why is that chart?
59.
Page 40.
Page 40.
Yes. Well, someone who has made this chart.
Now, who has given this computation? This was called for.
This is by the state on the basis of an order. So it's on affidavit. And on record, there was no recruitment process being initiated between 15 to 19. Lordship may kindly visualize these situations. There are always in every institutions large.
Yes. Now one clarification. Suppose there is total post 10.
Total posts?
10.
10, yes.
So out of which 5 it to be filled up from promotee and 5 is to be from direct.
Absolutely.
Now, present situation it suggests that there is
4 vacancy in the promoting,
Yes.
and there is 2 vacancy in the
In the direct recruiting. Yes.
So 4 vacancies to be filled up.
Yes.
So 1 from promoting and 3 from direct.
No difficulty as
then when vacancy would be arise, there is easy calculation to 50-54
no.
vacancies.
May I say this? No.
No.
No. There is a ceiling.
From the existing, it is to be ascertained from promoting quota how much vacancy, from direct quota how much vacancy.
May I say this?
Maybe 1 is to
But whatever quota is a secondary thing. The primary thing is what is the total number in the cadre. If what my learned friends are saying, if that is to be accepted, then for the direct recruitees, the number in the total cadre would be almost, it is much more than 75%. And this rule will have absolutely no basis. Lordship, may kindly visualize this. What was the purpose of the rule to say that 50% to the post? It means that no matter what is the number of vacancies, you cannot go beyond 50%. But if this is to be followed, it will go beyond 50% of the cadre strength.
No, if I say before the promulgation of the rule,
yes,
there was a quota. You think in this way.
There was statutorily no quota. This is the point for the first time I'm saying.
If anyone says that the post is to be filled up 75% from direct and 25% from promoting,
yes,
you think that there is a quota.
I take it for yes.
75% would be filled up from direct and 20% from promoting. It is a quota.
If there is a recruitment process,
carry forward the vacancy from here, most probably 10 is coming from promoting.
No, may I
and 50 is coming from here. Now then you cannot accumulate and say that entire post will be filled up from 50-50.
No, may I say this?
Because the vacancy is coming.
I have understood. My answer is in page 40 chart. Total number of supervisor in 2019 is only 1500. No, 15. Kindly see serial number 10. So this 1500 is not all promotees. This 1500 is combined promotees and direct recruitees.
It would be 50-50. It will be subsequently sanctioned.
No.
Post rule sanction post.
But if it is 50-50, then there is no quarrel.
Before that,
yes.
You are going to take out.
No, I am not.
The post fixed for.
May I say this? May I say this? But I have understood. I have understood Lordship's query.
What clarification?
Of course, no, not at all. May I say this? I say that occurrence of vacancy has to be in the context of a recruitment process. Now, why I am saying so? Otherwise, the substantive rule of 50% ceiling for each category will have no meaning at all. Kindly visualize that before 2015, the government decided not to fill up, let us say, maximum number of vacancies. It's a government choice. Nobody has a right, neither the promotees nor the direct recruitees, to hold it and to carry it forward. Therefore, when the note refers about occurrence of the vacancy, note is trying to take into account the fundamental principle. If the game has started, meaning thereby, if any recruitment process has started before 2015, that means if the occurrence of the vacancy in the context of the recruitment process is before 2015, then that number of vacancies will be 75-25. But we don't have, there is no requirement for us to go there, because the government in their chart clarified in serial number 9 that the sanctioning of the number of vacancies in 2019 is 4958. So sanctioning is the zero level, I would say, for a recruitment process. So zero level in 2019. So sanctioning itself. Yesterday, meaning thereby before 2019, I decided not to go for a recruitment. So therefore, I did not go ahead. So I sanction, I decide, I as a state, I think I want to go for a recruitment in 2019. Therefore, I sanction. Once I sanction this, that is an occurrence of vacancy post 2019.
No, tell us, Mr. Dhar,
Yes.
whether there had been any quota system, as my brother is saying.
My lord,
In the sense that 50% will be, if I have understood his query,
yes,
it's a 50%, 50%. Today at this juncture, maybe out of 50% in promoting quota, 10 are full,
yes,
and out of direct quota, 1 is full.
yes,
So naturally, the persons who are coming
correct.
will have to, the ratio of the
Has to be
proportion will
applied.
differ.
Agreed. Well, I think that there is a fundamental logic in that. I would say there is a quota.
Had there been any contention on their part that we are segregating the vacancies 50-50,
Yes.
but as per the status of vacancies,
Yes.
we are filling up 422 and 360.
No. Their logic is this. Well, their logic is very unique. Their logic is this whole cadre was created and there were existence of so they are taking into account all existings of vacancy. Kindly visualize 3009 and all 3009, that's why I said the figure becomes 12.5%. All 3009
are applied to 50-50.
Yes.
75.
They are using, they are banking on the what? Occurrence. They are trying to interpret occurrence is created, but occurrence has to be in the rule, the recruitment rule itself. Otherwise, it has got no value, no relevance.
Yes.
If I say this, my lord, mere existence of vacancy is not the occurrence of vacancy for interpretation of the note. And secondly, the 50% post, that's the ceiling that Lordship is saying. I agree with that. That no matter what happens, the promotees cannot get anything more than 50%. And I'm not asking that because their own figure is 4958 is the total number in 2019 sanctioning. 1500 are already working. So Lordship, kindly make the calculation. So remaining, because 3458, half of 3458 is 1729. All I'm asking this 1729. Now instead of 1729, they are making it how much? 400 and something, which is 12.5%.
Yes, your next point.
Yes, Malad, this is, I just said this. Just a second. 2004 13 SCC 25 paragraph 16 attending. This is on the point. Note cannot control the substantive provisions. Note is to explain a situation. It cannot do something so that whole 50% becomes 12.5%. Paragraph 16. Short. 2004 13 SCC 25. A note to a rule, paragraph 16. A note to a rule cannot derogate from the explicit words of the substantive provision and must be read as explanatory and in harmony with it. If today Mr. Bandyopadhyay's argument is to be taken, harmony from 50% goes to 12.5%. Harmony goes and control goes also. There is one more judgment. 2005 6 SCC 776. 6. 2005 6 SCC 776. Paragraph 22, 23 and 24.
All right.
This is same proposition. All I'm saying, this is the principle, my lord. I'm not required to say that this is the, there is not such divergent view. That note is supposed to explain the situation. And I do say that's the reason, my lord. The substantive provision has chosen the word post. So in the whole cadre, number of posts for the direct recruit is basically earmarked 50% of whatever. And that's why note is not using the post. Note is using the number vacancy.
But Mr. Dhod, how you are saying that the total cadre strength is that 4,000? 4,000 yes, as on January 2019.
Yes, which was sanctioned for recruitment.
Right. So now there may have been, apart from these posts, there were other filled up posts also.
No, there is no other filled up post. There is no other filled up post. May I so kindly come to chart again?
Page 41.
Yes, page 40. Page 40 itself.
This number of supervisors sanctioned.
I have read it. I spent some time to understand this.
Computation of
this can I use the word jugglery? Then I realized what they have done. Kindly see, my lord, serial number 6.
Yes.
Serial number 6, vacancy of supervisor as in September 2015. Kindly mark, this is a mere vacancy. 3009. All this 3009 for which no recruitment process was initiated.
Where you are getting?
Yes. Serial number 6.
Vacancy of supervisors
as in September 2015. It's a mere existence of vacancy.
Right.
For which no recruitment process ever initiated before 2015. So what they are doing?
So in 2015, the strength of the cadre was how much?
4958. That is there. They themselves say serial number 4. But there was no sanction to go for the recruitment for the 4958, which was there in 2019 only. In 2015, there were only 1949 persons working. Same number, because of retirement and other things, came down to 1500 in 2019. So they are taking the whole pool of the vacancies, which is mere existence of the vacancy, and no recruitment process been taken pre-2015, occurring in the context of. But this is so wrong.
Yes. Next, what do you want?
Yes. Yes, Lordship, I have said, my lord, the post and vacancy. There is a judgment 2020 2 SCC 173, paragraph 35.
2020
2 SCC 173, paragraph 35. Substantive provision is saying post, but the note has said the vacancy. I think that's very correct. But this is basically a 1995 judgment being followed in 2020 also. Paragraph 35.
Yes.
Reiterating the well-settled principle that the percentage of reservation has to be worked out in relation to number of posts which form cadre strength. Thereafter, by the quotation, the expression post and vacancies often used in the executive instructions providing for reservations are rather problematical, like today we are facing. The word post means an appointment, job, office, or employment, a position to which a person is appointed. Vacancy means an unoccupied post of office. That's a vacancy. The plain meaning of the two expressions make it clear that there must be a post in existence to enable the vacancy to occur. That's a recruitment process. The cadre strength is always measured by the number of posts comprising the cadre. Right to be considered for appointment can only be claimed in respect of a post in a cadre. As a consequence, the percentage of reservation has to be worked out in relation to the number of posts which form the cadre strength. The concept of vacancy has no relevance in operating the percent of reservations. That precisely, my lord, I was saying. The substantive rule says 50% for the direct, 50% for the promotees. That cannot be tinkered with. The note is only to address a situation if there is a recruitment process happened, or in their own language, if there is an occurrence of vacancy pre-15 in the context of a recruitment process, 75-25 can be done. But that is not there here. There is no reason for a note to be applied by your lordships because of 2019 being sanctioned itself.
Yes.
Yes, my lord. My lord, Mr. Bandyopadhyay has, there is one judgment 2023 3 SCC 773, paragraph 85.1, where the judgment relied by Mr. Bandyopadhyay has clearly been overruled.
Which judgment? 2023 SCC on?
This is the 2023, it's a larger bench. 3 SCC 773, Rajkumar. This has overruled 83 3 SCC 284, Rangaya. এটা হচ্ছে 23 3 SCC 773.
No, he has not relied 20.
He has relied.
He has given 23 SCC online.
He has also given 83 3 SCC 284.
SCC, yes, 83 3 SCC 280.
Exactly. So 83 3 SCC 284 has been overruled by the judgment I have placed. 85.1 paragraph. Para 85.1. In fact, this is for academic, because after 2019 sanctioning, nothing is required, but still 85.1, Mela short para. The statement in Rangaya that the vacancies which occurred prior to the amended rules would be governed by the old rules and not by the amended rules does not reflect the correct proposition of law governing services under the Union and the states under Part 14 of the Constitution. It is hereby overruled. So,
but Rangaya was relating to exclusively to promotion, not fresh filling up.
My lord, Mr. Yes, that's why I said this is, I am only showing that
your case is a combined effect.
Yes.
Promotion and
yes. My lord, in fact, if I can summarize.
Yes.
Because I have nothing more to say. I say that the recruitment rule itself is of 2019, sanctioning by their own chart for recruitment. That's the matter. The for recruitment in 2019, as per their own chart, sanctioning in 2019 was 4,958. As per their own chart, 1,500 are already working. So I minus that. So figure becomes 3,458. So this 3,458, my respectful submission, is the occurrence of vacancy for recruitment or in the context of recruitment in 2019. And therefore, half of it promotees are entitled to. And consequently, page 31, instead of giving us half, they have given us 422. So they are giving us, instead of 50%, they are giving us 12.5%. Well, this is wrong. It is incorrect. And a single judge has directed for a 50-50 on a correct understanding of the rule itself.
What do you say about this?
That any reasoning can be supplemented by. All I am saying, if the fundamental point is right, Lordships can always provide reasoning. I'm not saying whether I succeed or my learned friends succeed. All I submit before Lordship is dealing with the situations where large number of persons will ultimately be affected. So there might be a sentence which learned single judge might not happily written it. All I am saying, whatever is the correct position of law, Lordship can always tinker with that.
No, what is that central government, Mr.
Yes.
Bandyopadhyay drew our attention?
Well, that is at
36.
36.
Now, please explain to us what is the purpose of this.
Yes, well, in fact, that is correct. That is a very good point in my favor. But since Mr. Bandyopadhyay was more on the point, we have a discretion to make our own rule. No matter what central government has done, we'll go by only after framing the rule. So I made a discount on my submissions. So I did not make any submissions that, look, this 15 is binding on you. In 24, you cannot say. Now, may I say this? Whole object would be diluted if this is not done. Kindly see 15 September 15.
Yes.
May I place it?
Yes.
As you are aware, the Anganwadi workers are the most important functionary at the village level. Under the ICDS scheme, recent years have witnessed not only an exponential increase in the Anganwadi centers, Anganwadi workers, but also significant special efforts aimed at ensuring quality in the delivery of services and community participation. Accordingly, the responsibilities of the Anganwadi worker has increased tremendously, and she is now required to perform multiple tasks ranging from delivery of vital services involving community women groups, Mohila Mondols, and for ensuring the effective convergence of various sector services. In the broad framework for implementation of restructural ICDS approved by the Cabinet, with the restructuring and strengthening of ICDS, the following provision for rationalization of appointment of Anganwadis as supervisors have been made. 25% post of supervisor reserved for Anganwadis would be filled by the method of induction under the ICDS mission, subject to fulfillment of desired educational qualification and age criteria. An additional provision for filling up 25% of vacant posts from Anganwadis based on their merit and track record of service, an additional qualification would also be made. The above position has been reviewed, keeping in view the aspirations of these field functionaries to encourage their participations in the higher post vis-a-vis their merit and to improve their career prospects. The following guidelines on promotions and appointment of Anganwadis to the post of supervisor in supersession of earlier guidelines are conveyed to the states and union territories for compliance. Number 1, the 50% of vacancies in the post of supervisor would be filled up by promotions from amongst Anganwadis with 10 years of experience in Anganwadis and having the prescribed educational qualifications as per the recruitment rules for the post of supervisor, filling which.
So this is in your favor.
Yes. Lordship, kindly look at the object. There are some women who are dealing with some basic need and they are functioning. So we as a government, the cabinet, the central government thought we have to provide them some better hope. So therefore, we make it 50% of the next post supervisor should come from all these persons subject to ABCD, 10 years, some educational qualifications. So that is a kind of hope which is catered so that their continuance of service, their emergency working in different fields at the village level, that is encouraged. Now, today, if it is brought down to 12.5% in this mystical way, well, this will completely go against this. Learned Single Judge has not gone into the rule part of it so much, but Learned Single Judge has said that 2015, this was 50-50. Today we are 2024, and the recruitment process initiated in 2009. Sorry.
Come back to page 31.
Yes.
Where is this memo of 22nd February 2019? Second line.
Yes, well, I'm coming. Second line, VDA UA number dated 22nd to 19.
That is not there, no?
This is, well, may I just check? This is.
You have 25th February.
Correct.
Not the 22nd one.
Yes. So it seems recruitment rule, then cabinet decision, this total number of vacancies. So that's, in Lordship's language, that's some kind of initiation for the, or in the context of recruitment. That's the beginning. If that is the beginning, my lord, that is the end of the matter.
Where is the, what did you say?
I said that I am directed to inform you that 55th meeting of cabinet held on 21st February 2019 has approved Icds EO number such and such dated 22 to 19. Roman 1, recruitment rule for the post of supervisor under Icds. Roman 2, filling up of vacancies of 3376 posts. I am on this. Roman 2 is a decision taken by the cabinet in 2019
to fill up 337.
Yes,
that has to be 50-50.
Yes.
Yes.
Well, I have nothing to say. Deeply appreciate.
May I have a very short submission, my lord.
Before going into
My lord, I have a very short submission, my lord, in respect of
who does not.
Pardon, what you are saying?
Saying that the page 31.
You tell us you are for whom?
I have 493 mat number, the writ petitioner in the trial court, in the court below.
Writ petitioner in 493.
Yes, mat MAT number 493.
1, 2, 3.
That is, you are at par with Mr.
Yes,
Thor.
but some points I am just pointing out before Lordship, that is page 31, the vacancy notification is 3376.
Page 31.
The vacancy was declared 3376. But when we challenge this matter before the trial by single bench, then the single bench sought for report. In the report, that is page 40.
Yes.
There is anomaly of vacancy, Here we found that the serial number 11, the 3458.
Yes.
The vacancy are not tally with the advertisement,
That is 3476.
Yes, 3376.
3376.
3376.
We are not
number is
required
not
to
telling
go into the nitty-gritties. We are to decide whether percentage will be 50-50 or 75-25.
Yes, that will survive. But one.
No, how does that help you? If the figures do not tally, how does that help you?
But there is anomaly in the recruitment process. That's why.
This report does not tally with the
vacancies
as stated in page 31.
31.
Yes, anything else, Mr.?
And one irregularity, page 40 in para 1.
Page 40, para 1.
Yes, para 1.
Yes, what do you say?
Serial number 1,
Serial number 1.
There are A, B, C, D, E, F, G, H heads.
Yes.
But in paragraph 1, it is found from their report, they have already given 50% prior to 15, So there is total anomaly.
What?
In serial number 1,
Yes.
Well, they have already 1500 vacancy was there in C.
Where do you find 15,000?
Para 1 and 2. Next 2, So 1 is September.
2 is for
January
50-50
19.
ratio.
January 1950. 1500. And before that, just above
100 for supervisor.
Just above, September 15. 1949.
Yes.
There was also, my lord, the D and E, my lord. There was ratio 50-50. D and E, my lord. Can you see the D and E?
Directly
Nine-
selected
96
964.
964, and my lord, the promotion is 984.
Yes.
85.
That is 50-50.
There was 50-50 before 2015.
No, what should be, what they are saying. Up to September 25, total number of supervisor 1949.
Yes.
And existed directly, out of which directly was recruited was 964. And promotion from 985. But it should be
25.
75,
25.
25.
Yes, my lord.
So 75, 25 should have been 1468 and 487. But in reality, there was a promote of 985.
490.
That means excess in promote
Not seen.
quota.
Not seen.
Hence, I am using the word quota, though legislature has not.
সেটা তোমার
F 494. Similarly, in January year, 16% in excess in promoting quota was recruited. That means previously there was 514 promoting candidate was appointed in excess.
In excess.
Now they are to be adjusted.
Just one the concept of excess will only come when it goes beyond 50% of the cadre strength. That's the substantive provision. So whole excess is their imaginary excess. Excess will be when I go beyond 50%. Otherwise, no concept. This is an absolutely wrong excess. Their understanding. Kindly think over this.
this calculation of excess itself is discrepant.
Absolutely, yes. Yes. Exactly.
My lord, I have a very short submission, my lord. I am appearing for can 6 and 7.
ওরা মেলাচ্ছে back
My lord, I am appearing for can 6 and 7, my lord.
The magic here.
যেটা বলছে যে ওই এক্সেসটাকে আমরা অফিসের সাথে অ্যাডজাস্ট করিয়ে এই রেশিওতে আনছি।
My lord, I can 6 and 7.
And I adopted Mr. Dhor's submission.
No, this 498 and 16 as per the chart was in excess. The 498 in promotion quota was in excess prior to the cutout date. So, Mr. Bandyopadhyay, how you are explaining that this 498 you are
Excess in the promoted pool.
very good. Now, how you are adjusting that with this present?
Yes. Your lordship will kindly take that at serial number 7. Serial number 7.
Yes.
Can I take serial number 7? Once we apply 7, we get, it should be application of 75 to 25 will take us to 752 in serial number 6 Roman 2. Your lordship will find 752.
Yes.
In the next row, that is serial number 7, actually to be selected from promotion 752 minus 498. That excess 498 is being adjusted here.
The vacancy never.
Where is this reflection in your memo?
Reflection.
Where is this adjustment of?
The memo
We will go to
this working out.
No, we will go to that. Your explanation is that there was an excess in promotion. So if there was an excess in promotion, this ought to have been considered by the cabinet. So if cabinet after consideration, how it is saying that 3376 will be for
Total 2954.
total 2954 will be for direct and
420 for promoting.
how you are
Exact figure in that notes. Kindly take note, page 31.
page 31 is 7th March.
That is impugned. That is the only impugned memo.
Mm-hmm.
Kindly take 422 number of posts will be filled up 4th line.
Yes.
422 will be filled up by promotion. And 6th line, the remaining 2954 will be by direct recruitment. This is that figure being matched.
How you
20 and 20.
no how this
Serial number
this,
20
this
and 20.
segregation then does not
Madam,
tally
Madam,
with 70. Please, I'm questioning this. These 422 2954 figures are in tandem with 3376 total vacancies. So if you say that adjusting the excess promotion, we have come to this figure that disturbs your own ratio.
But it won't.
Why? Because it
after
comes to
application of
12.5 is to 87.5.
That's one of the roundabout one of the calculation which is being done today.
So you are allowing them to make such calculation.
Page 40. Malad, you will kindly appreciate this.
Yes.
Page 40, kindly take serial number 20 and 21. 20 and 21. 20 is 2954. Just check over it. 21 is 422. After this 23 lines of calculation, we come to these two figures. And
now, why you are
by the cabinet?
Just. Why you are subtracting 41 from both of them?
Because in the meantime, 41 in Jungle Mahal was given for direct, 41 was given in Jungle Mahal for promotion. This 41 plus 41, 82 has been deducted. That is also there in serial number 16 and 17. So we have not hidden anything. Strong adjectives may be used against this calculation. I am appalled to see this. It is strange. Wrong has been done by the state. But we have laid our hands very clearly how we have calculated. At serial number 20 and 21, the figures are there, which is reflected in the impugned memo.
No, very good. That then the state also is logically arriving at this. State is saying 2954 is for promotion and 422 is for direct. Now, this calculation you are coming after adjusting the previously existing vacancies.
As on the date of the cutoff. As of the date of the cutoff.
Cutoff on 15 September 2015, there must have been some maybe excess or deficiency in the quota respective quota.
Either of the two.
Then on the basis of which provision are you adjusting this?
As on that date, the requirement was that the ratio should be 75 to 25.
Right, understood.
And in the next regime,
it will be 50-50.
We have gone by that, Madam.
How?
It is not.
Show us one document which allows you to do so.
Your Lordship will kindly see this.
Now, please answer our question. Then we will hear your argument. We are wanting to know from you, as you have rightly pointed out, that you cannot just take up the vacancy suddenly one fine morning. On the date you are calculating, you have to take into effect, according to you, the number in excess and the number in deficit.
Yes.
Which provision permits you to do that? That you can adjust the excess and deficiency existing as on prior to 15 September with the vacancies which you are going to fill up in the newspaper.
15 September, the requirement was 75 to 25. That's the admitted case of all parties.
Right. But there was an excess.
There was an excess.
Right.
Which is at the time of recruitment, my lord, this calculation is being done to bring it within that ratio.
Then there must be a line to that effect in your cabinet decision, as you are subtracting the Jungle Mahal. Jungle Mahal you are subtracting. For that reason, everybody we are accepting.
May I kindly say this? What is their approval in the cabinet memo is 2954 and 422.
Right.
Now, this 2954 and 422 are not figures we are plucking out of thin air. This 2954 and 422 is a deduction from serial number 1 to serial number 19. If serial number 1 to serial number 19 at page 40 will not have been there, then we will not come to serial number 20 and 21 this calculation. Therefore, when
that is your argument, Mr. Bandyopadhyay. Please satisfy us on this issue that this adjustment is reflected from the records. You are coming up with a chart in answer to the court query.
Spend a few more minutes on this chart.
Certainly, sir. We want to listen to that.
May I make one humble submission? My lord, can 7 and 8, only 2 minutes, my lord, I will take of your lordships. Can 7 and 8, I am a direct recruitment, my lord.
Addition of party, which I am opposing.
Addition of party?
2 applications for addition of party, your lordship has kept for the final hearing, which I am opposing, my lord. Because their cause of action is not with regard to the ratio.
Hold prayer, my lord. If your lordship holds that it should be 75 and 25, then, my lord, and getting an appointment, even if it is 50-50, I am getting an appointment. Only difficulty is that they are following 50-50 pursuant to order passed by the single judge. And they have appointed person below me. I have prepared a chart. Only thing, whatever your lordship holds, it should be according to merit so that nobody, whoever in the panel is not left out. This is my only limited prayer before your lordship.
This is not the subject matter.
As a 1 minute, total post is 4958.
Yes.
Total.
Yes, my lord.
Now, before
Half.
2005, how many vacancy arrows?
3009.
Before,
2009.
no, before 2000,
That is serial number 6.
2000, before 2015, it was also 4958.
Post, not vacancy.
Post.
As you have entered
Yes, correct,
us,
correct.
4958. I have to take my lord.
No, I'm saying,
vacancy,
correct.
you have stated.
Before,
Post may be 100.
correct.
Out of which 10 is vacant.
4958.
90 feet.
No, vacancy was 3000.
Post.
No.
পোস্টটা থাকুক
Post is 4958.
So total post
Yes.
4958.
Half is 2479.
With vacancy arrows before 2015 3009.
Not vacancy arrows. Vacancy merely existed because of no recruitment. These two things are different.
No recruitment.
Vacancy arrows has to, lordship, getting the what from a recruitment rule.
Exists.
Yes, mere existence of it. 3009.
3009.
Right.
Acha. After that cutoff date,
Yes.
how many vacancy were there?
449.
Just a
449.
second. This is
349 serial number 12.
No.
If I'm wrong, correct.
My lord, in 2019, total number, kindly take serial number 9, 10 and 11. Yes.
449.
449 serial number 12.
Just a second, let me see.
449.
3458 minus 3000.
Serial number 12, 1 or 2?
12. Only 12. Plain 12.
Okay, plain 12.
Vacancy of supervisor.
Vacancy of supervisor between 15, correct.
Yes.
Right, 449.
449.
Yes.
So now they are claiming the out of
No,
449,
what is the next column? Out of which to be
50-50 is applied.
50-50.
449 we are dividing into 224 and 225.
That would be, my lord, disastrous to the rule.
আচ্ছা, let us let us
Because why? Half of all I say, the half of 4958 is 2479.
75.
They have a complete freedom to do anything within 2479. Half of 4958 is 2479. I do not say to them they can do anything with 2479. But the moment they want to cross 2479, they will hit the rule itself. Because then it will be exceeding 50% of.
If they start a separate selection process
Yes.
in respect of 3090,
They did not.
getting that it would be
Had they started so, things would have been different. But they did not. And there the lordship's judgment comes.
If you added, the promoter will get benefit.
No, promoter will not. Kindly see, promoter will not get the benefit because promotees have to be satisfied with half of 4958. Therefore, no matter what happens, the promotee cannot go beyond 2479.
No. That defeats his argument. That defeats my learning
Yes,
his argument.
kindly calculate.
495 is total. That means there are existing and vacant. 4958 is posts. So there are existing persons. If we restrict it to 50-50, then the existing persons, if there is an excess, they will have to be thrown out of the service.
Existing is only 1500.
Our next friend's argument is that they have to be adjusted. He is making the same argument in a different bottle.
we are not on that, Mr. Bandyopadhyay. You explain us this adjustment is pursuant to the show us that.
Lord, yes. Lord,
This adjustment is in consonance with this memo. Only show us that we dismiss you, we allow your appeal, we set aside the order.
Lord, prior to September 2015, the ratio to be applied is 75:25. That is an admitted case of all parties.
Yes.
So, my lord, as on September 2015, the total number of supervisors were 1949. I am at serial number 1. And there is a 964 direct recruitees and 985 promotees as supervisors.
But as on that day, what was required was 75:25. The next two columns are what it should be. Kindly take the heading, what it should be. It should be 1462:487.
অনেকটা বেনিফিট এটা যদি আমাকে 70 এটা সাধারণ একটা এরা 2500 দাঁড়াবে, এরা 2700
না না 15-তে এক্সট্রা অ্যাক্সেস ছিল 98
No, no, সেম ক্যাবিনেটের কোনো কপি টাচ করা যাবে না, ক্যালকুলেশনটা থেকে এই না জায়গাতে এসছে।
এটা তো নোটিং
ভ্যাকেন্সি এটা হবে
নোটিফিকেশন তো হচ্ছে রিক্রুটমেন্ট সিলেকশন
এখন অলরেডি তো করে ফেলেছে মোদি। অলরেডি তো
চাকরি চলে গেছে
আচ্ছা আচ্ছা করছে তাদের সেটা পরবর্তী
চাকরি করছে কোথায়? চাকরি তো বলেছে যে তুমি 50-50-তে করো।
অলরেডি
হ্যাঁ 50-50
If your logic kindly takes page 40, what I am trying to submit is that what is impugned before your lordship is page 31, which is the memo of 7th of March 2019, which gives a figure of 422 and 2954. This 422 and 2954 is a result of some deduction. The result of some deduction. That deduction, upon being called for by the Honorable Court, we have given in the additional affidavit, that is page 40. That is page 40. Your lordship will find that calculation at serial number 20 and 21. Now, my lord, your lordships will find at serial number 6.
Now, just one question. When you are making the 7th March 2019, you are not prescribing the ratio in the preamble. You are saying, no, we are filling up 343376, out of which 422 and 2954. This is supporting which ratio?
But this is supporting the ratio as applied at page 40. And why I say that, my lord will kindly, my lord, with the deepest of respect, my lord, will kindly not expect that memo of 7th of March to contain the entire calculation in the first paragraph. The final figures have been given. The calculation is there in our record, in our files, which we have reproduced in page 40. It is not that we have arrived at that figure without any calculation or any deduction. It is not that we have arrived at that figure without applying 75:25 or 50-50 at the relevant point of time. What has fallen for decision is that whether our application of a cutoff date was right or wrong. Whether we applied this cutoff rightly or wrongly, thereby applying 75:25 to 3009 vacancies, which occurred prior to 15 September 2015, and applied 50-50 to the remaining vacancies which occurred after 15th of September 2015. This is what has fallen for consideration before Lordship. Now, my lord, this calculation of 2954 and how it has been applied, my lord, with the deepest of respect, my lord, that was not challenged. Now, this I agree, my lord, 7th of March 2019 does not contain the calculation in the memo itself. But what I am trying to say is that the figures which 7th of March 2019 contain is out of a calculation which is there in our file. It is not something utopian or
That
we have
page
come up
40.
with.
That is
Page
page
40.
40. Yes.
That is page 40. Now your lordship will find a figure in page 40 at serial number 11. That is 3458. Serial number 11, 3458.
Yes.
At serial number 11. This is the number, this is vacancy of supervisors as in January 2019.
Including
Prior to September 2015 and post September 2015. To this, the Honorable Single Judge has applied 50-50 ratio as a whole, without seeing what has gone in Jungle Mall, what is covered, what is not covered, who is existing in the post, who is not existing in the post. Nothing has been considered. But assuming our calculation is wrong, my lord, going by that, we'll have to throw everyone out in the Jungle Mall recruitment which has happened, which is mentioned in serial number 16 and 17, and do it afresh.
No, we are not touching that. We are on
the application of the ratio. Malad, this application of the ratio is at 6, serial number 6, Roman 1.
It was the 3458 was the vacancy you had considered.
Yes.
So 3458.
The bifurcation is 3009.
Now where does this figure 3376 come?
3376, my lord, is addition of 2954 and 422. That is serial number 20 and 21.
Achha.
That is the same figures mentioned in the impugned memo. But in the advertisement, your lordship will only find the figure 2954. Because for promoters, that advertisement was not applicable. It was separately the 2954.
So you are saying that as per your calculation, you have taken into consideration the excess and deficiency in the respective parts. And you have come to the conclusion that 3376 is the vacancy. 3376 is the vacancy for which you have applied what ratio?
Yes. Well, 2 serial numbers. Kindly take 6 Roman 1 and
if we
12
go by
Roman
your
1.
argument, then 3376 you will be filling up by 50 is to 50.
No.
Why?
Because of serial number 6, kindly take serial number. This 3376 has 2 parts. One is 3009. That is prior to September 2015. 3009 vacancies occurred prior to September 2015 and 449 vacancies occurred after September 2015. These relevant serial numbers are serial number 6 and serial number 12. Serial numbers plain 6, not Roman, numerical 6 and numerical 12.
So there were 3009 vacancies prior to
September 2015
and 449 after.
Now
total will
come to 3458.
3458.
From this 82 is to be deducted, but deduction comes later. Next step is 6 Roman 1 and 12 Roman 1. But these two serial numbers are extremely important. Kindly takes it for my satisfaction once. In 6 Roman 1, we apply 75 is to 25 to 3009 vacancies. This is where my learned seniors are joining the issue that you could not have done that because the recruitment process was not prior to 15 September 2015. Serial number 1 and serial number 12 Roman 1, where we have applied 50-50 to 449 vacancies. Question is whether in law we have done this rightly or not. Whether we were right in bifurcating it or we should have applied it 50-50 to the entire vacancy available to us in January 2019. To that, irrespective of Rangaya being overruled, my answer is that there is no straitjacket law which will force the state to apply the law as on the date of the law, on the date of recruitment. And that judgment that Mr. Dhar had cited, my lord, when it was pointed out by your lordship when I was making my submission that it has been overruled, I went home and did my own homework, my lord. If your lordship kindly takes that judgment once, that 2023 3 SCC 773.
So why were you not cautious in framing the rule? These occasions could have been washed away.
But there has been
There
has been no infringement. My learned friends know that. My learned friends sat on the fence, waited for these matters to be concluded. They did not come before the writ court challenging it, my lord. Kindly remember this. They are before the appeal court for the first time. Only my learned Mr. Banerjee's client was there before the writ court. Mr. Dhar's client was not there. They did not challenge the rule. They did not challenge the note. Today, these submissions are being made. They have not come up with
they were not parties to the proceeding.
No, they came by way of addition of party in the mandamus appeal. They have not challenged the rules. They have not challenged the advertisement. But I am trying to repeatedly make this submission that the rule, the note, irrespective of bunch of decisions being shown, the rule and the note is not under challenge. Interpretation of the rule and the note is not under challenge. Whether note will override the substantive provision or substantive provision will override the note, that is not the subject matter of the litigation. These are distributaries supported by hefty adjectives. Now, my lord, kindly in that 2023, kindly takes paragraphs 82.5 and 85.
Prerogative of the council. Hefty.
But I am not being able to match them. My lord, kindly takes in the 2023 3 SCC, my lord, that is Rajkumar, my lord. And my lord, there are at least 8 to 10 other decisions which I don't want to show in reply, but my point is very clearly made out in 82.5 and 85. Kindly takes that. And that is why, my lord, other decisions are not being shown, because the golden thread is this. There is no bar on the state.
Yes.
82.5.
Yes.
When there is no statutory duty cast upon the state to consider appointment to vacancies that existed prior to amendment, the state cannot be directed to consider the same. Therefore, there is no bar on the state. No mandamus can be issued on the state that you go by this, but there is no bar on the state to apply that law. Also, kindly takes 85. Just prior to 85.1, which was placed by Mr. Dhar, kindly takes 85. The consistent findings in these 15 decisions that Rangaiah case must be seen in the context of its own facts, coupled with the declaration that there is no rule of universal application to the effect that vacancies must necessarily be filled on the basis of the rules which existed on the date which they arose. Therefore, it is up to the state to make this decision that which law to apply to the recruitment. But no mandamus can be issued upon the state that you only apply the law which is existing today. This administrative choice has to be left to the state.
That cannot be said to be false within the sole discretion of the state. State is duty bound to follow the statutory rule.
Yes, but for that,
state is there not to confuse the litigants.
Actually, we want to another clarification from Mr. Dhar. Mr. Dhar, as and when the legislature declared that the total post, 50% of the total post will be filled up directly, and 50% will be filled up by promoting.
Right.
The legislature intended that to create a quota system and to
correct
a reserve.
Yes, I cannot go beyond that. Exactly.
That means 50% you consider the first institution.
Exactly. But they will go beyond 50%.
50% of the total post.
Yes.
I am not using
correct.
The word
total post. Correct.
Post.
Yes.
Reserved for the promotee, 50% will be direct.
Correct.
Now vacancy occurs
due
to death of the employee.
True.
True. Due to transfer.
Correct.
Due to anyone has left the job.
Correct.
Then vacancy was 10.
Yes.
And 10 occur, again I am saying, 5 from 6 from promotee.
Yes.
And 4 from direct.
But it cannot exceed 50% of the post.
Claim, as and when vacancy will arise, it used to be filled up 50-50.
No, but ceiling is 50. If what state is going to do is to be accepted, then it will go beyond 50 for the direct recruitees.
No.
Yes, it will.
I am giving just this calculation to you. 3,000 total vacancy.
Yes.
And next vacancy.
Finally, first take the total cadre. 4958 is the total cadre. Serial number 9.
You forget about the same.
Okay.
Total vacancy is yes. Okay. Total cadre.
Yes.
Total
So now
cadre,
first
4958.
Yes. Now
out of which
2479 is the ceiling.
2479.
So no one can cross 2479.
2479.
Right.
Okay, let us see.
Yes, whether they have crossed or we are crossing.
Now.
Kindly see, we have not crossed it.
Yeah, 3009.
No, ours is only 766 as on date.
Now they are claiming that 3009
yes
is to be filled up by 75-25 days.
Yes.
That means he will get approximately 750 and odds.
Yes.
3000 and 750 on odds.
Still within 2479.
So I am for sake of argument, I am 750.
Yes.
And 50-50 from 449.
Yes.
That is 200 220.
No, that 75-25. No, one thing. That 75-25 lordships cannot take unless lordship holds that there was a situations when recruitment process occurred.
Allow me.
Yes, sorry.
My thinking.
Yes, that is the beauty of.
Now that would be 994.
Yes.
You will get 994 according to them.
Yes.
994. And if the existing
yes
is calculated, then what would
kindly take existing is 766 promotees. 766.
766.
Yes, that is their figure.
As Anganwadi in 2, serial 2.
What number serial?
Serial 2.
2E.
Yes, kindly see serial number 2.
2E. Yes. 2E.
2E. Yes. Yeah, correct. 2E. 766.
E.
Yes, 766 is existing promotees. Now my ceiling, kindly take my ceiling if I consider 50% of the cadre. 50% of the cadre means 2479.
Now you want.
I want 2479 minus 766.
Okay. And
that's why I said it is.
How much total?
All I said that I can go up to 2479. I am not asking beyond that.
Now 50-50 direction is giving.
Yes.
More post from promote you will be filled up. 494. You calculate.
Lordship, kindly see. Two things. Lordship is saying that it should be 50-50. I am also saying that. Then what is the
post, not vacancy?
Yes, I'm saying post. Vacancy is the lesser thing. 50-50 of the post. Now 50-50 of the post, if it is to be translated for the understanding really, what does it mean? It means 2479. 2479 I cannot exceed, 2479 they cannot exceed. Now today what we have? 766. So I say that give 2479 minus 766, give me that, because that comes under the rule.
Minus 41.
But what they want to do is, they take the whole existing vacancy without any recruitment process being initiated. So it becomes 12.5%.
Without interrupting my learned senior, my lord, if this is put down in writing and
yes,
seen with the impugned order, your lordship will again feel that going by that calculation also the impugned decision is wrong. Wrong in law.
Impugned decision, if there is an incorrectness, lordships are there to correct it. But the point is, there has to be correct answer of law.
May give reasons if the reasons are not adequate. But if the conclusion is right. But if the conclusion is wrong, then the entire order changes.
But this is not a technical. Ultimately, can we
going
give
by Mr. Dhaw's own argument that impugned order
can we
is
give a short note? Can we give a just short
not required?
But that is the CAN application I am opposing, my lord.
Before going,
Yes.
Before that, now.
Your Lordship, tell me if your Lordship need any clarification after the submission, then your Lordship will call me.
প্রিজাম্পশন হবে গুড সেটা স্টিল দুটো এলো পত্রিকা এরকম করে যদি আমার পার্সেন্ট হয়ে যায় তাহলে তো ইয়ে হয়ে যেমন ভ্যাকেন্সি যখন ডিক্লেয়ার করা হয় তখন প্রমোটিভ সেটা তো আমরা বানাচ্ছি এটা তো মেমোতে বলে কোন মেমোতে পোস্ট করেছে ভ্যাকেন্সি না না মেমোতে দেখুন পোস্ট এইখানে ভ্যাকেন্সি মানে পোস্টটা যত যতটা বলে এখান থেকে 50 এখানে 200টা কিন্তু এদের জায়গা থেকে ভর্তি করতে হবে 50টা এইভাবে যদি যেতে হয় তখন দেখা যাবে একজনকার বেশি হচ্ছে একজনকার কম দেখছি এইটা existing vacancy is to মানে vacancy is to be 100% rate যদি না ইয়ে হয় তাহলে কিন্তু পরবর্তী ক্ষেত্রে সেগুলো কিন্তু অ্যাডজাস্ট করে এখন যদি সেটা 50-50 বেশি একটু ভর্তি করলে যদি না কারণ বেশি
that point. What Lordship is thinking, I have already calculated, far less.
If now direction is given, you fill up 50-50.
Yes, we are happy.
Whether you will and in addition to the existing post,
Yes.
whether you will exceed the
It will not.
post,
It will not exceed 7. I said number. Nothing is it. A number is 766. Cut 766 from the 50% of it. Give it to that. But it should never be only 400.
And now total post is 3376.
No. Total post is
4958.
4958.
Vacancy 376.
Post, sorry, vacancy. Total vacancy.
No, Lordship.
376.
No, Lordship.
Half of that.
345.
No.
Half of that.
No, first Lordship has to.
1688.
Yes.
Plus 7 such and such.
Plus 766.
Is still not reaching that target of not reaching 2479.
টোটাল কাডার স্ট্রেংথের পোস্টটা নিয়ে ওটা কি 70
করে দিচ্ছে
চিন্তা
এরাও একটু বলবে
yes
many things has been said about numbers. I think not this case should not concern your Lordship the numbers because of this rule. Kindly come to page 51, that's the rule. The rule is not under challenge.
You are not required to challenge the law.
Commentary corona.
Yes. 51.
So this is not under challenge.
Yeah.
It's a rule made under provision to Article 309. And Mr. Dhor cited a case saying note cannot really disrupt the entire body of the scheme. Kindly say note. It refers to the body of the scheme. This is not a one-time exercise, this rule. This rule has come to stay. But at the present moment, there is a departure from this. That is why note specifically mentioned that up to vacancies 30th September 2015, one way and otherwise. So it's not a one-time exercise. Note is a one-time exercise. Therefore, note cannot destroy the main point. After 2 years, when promotions are given, recruitments are made, 50-50 will be there. 50-50 has come to stay. But the point is, when the rules under 309, they specify, after taking into consideration, in case of vacancies of such a ratio, direct recruitment indicated in Rule 3A. Therefore, Rule 3A has been taken note of. And recruitment from category of Anganwadi worker, as indicated in 3B, that is also taken note of.
They ought to have stated selection. Problem would have ended. Instead of recruitment, they ought to have stated selection.
May I tell you one thing?
And you also know that, Mr. Singh.
I know nothing of law. Therefore, Lord, kindly do not, kindly see. We have said, in case of vacancies such and such, the ratio of direct recruitments.
Directly.
As indicated, question is why this recruitment term has been issued. And
recruitment includes selection.
Recruitment is the starting point.
No, recruitment is not the starting point. Advertisement is the starting point.
No.
Recruitment is on much earlier.
May I subject to correction by your lordships? As I understand, recruitment is a process that starts for the purpose of selection.
No. Instead of going into that, you may say that this is not under challenge by.
That's right. That's what
we need not dwell on that. Yes.
After this, nothing remains in the writ petition.
All right, Mr. Sridhar. Yes, Mr. Banerjee, what you have to say?
I have two applications, CAN 6 and CAN 7, in Appeal 509.
CAN 6 and CAN 7.
For addition of parties.
With Mr.
Mr. Dhors is appearing for the direct Mr. Shudipta Dasgupta. Mr. Shudipta Dasgupta, he is appearing with. Yes.
With you?
Yes.
Oh, you have filed these two applications in MAT?
I promoted.
You have filed in MAT?
509.
509?
Yes.
Achha. Yes, who are you?
Directly. I am caught in the crossfire. I tell you, Lordship, why? Be it 75-25, be it 50-50, we are so meritorious that we have to be given appointment, irrespective of the ratio of which the government wants to go with. But because of this crossfire, our appointments are held. We only say this, let this dispute be adjudicated upon, but that should not be an impediment for our appointment.
Why you have the coordinate bench has said fill up this much?
That is not happening because of this litigation.
It will happen soon.
Yes, my lord will kindly make a time frame.
Your inclusion will not ask us to deliver the judgment tomorrow.
But kindly take care of us also, so that we get our recruitment, our appointment.
Dispose of, sir, what is your problem? You will come.
They are opposing that addition of party. Their cause of action has nothing to do with the ratio.
That we have heard, you have said so.
Yes, paragraph 4 of both the applications is their case.
Yes.
They are at a stage of reservation. Subsequently, your lordship deciding this matter, that what should be the number of vacancies either there, direct or promoted. They say that in the next stage, reservation policy has not been made. Paragraph 4 in both the applications. Sorry, my lord. Paragraph 4 in CAN 6 and paragraph 8 in CAN 7.
No, his anxiety is.
I am not getting into these things at all.
We are not following the reservation.
No,
and
you are
this
not.
roster should be maintained. Well, that's what we say.
Judgment has not been followed. You have given appointment.
Their point is in CAN.
Has that order been complied with anybody?
50%.
50%.
50%. But my lord, that is not their point.
Up to 50% added. Appointed.
1529. Out of 1729.
1729.
But that has happened without following the roster. There lies a
Let us understand
1529 has been executed without prejudice to anyone's rights and contentions and in terms of the interim order in this appeal.
From direct equity or
Directly.
yes,
from direct as well as promotion.
From direct.
from direct.
Achha.
from direct. So direct take off.
And promotee is 401.
Promote is 401.
Both are under either of the threshold. But Mr. Banerjee's point is that in
401 promote is given.
yes, 401.
Yes. So coordinate bench order complied with.
To that extent, no.
It's not
May I
complied.
put it in this way? Interim order in this appeal complied with.
Yes, that is what.
In this appeal. But Mr. Banerjee's point is that in this figure that your lordship noted, my lord.
You have Mr. Banerjee is in which card? Direct.
Yeah, direct.
Direct.
He is saying that we have not given appropriate reservation to OBCA, and in Can 7 he is saying not appropriate reservation
But
to
the 100-point roster has
You have not yet, but 1529 has been
I
appointed.
have not yet been.
1529 appointed.
Yes.
You are not coming within that.
Yes.
That due to the mistakes in roster.
Yes.
100-point roster. That is
And
not
Miller,
the subject matter of
yes,
the
and Miller, that has culminated because of this dispute, this thief
This
only.
is a civil post. They have to go
This
before the
thief only.
tribunal. They must approach the tribunal.
Miller, state is Miller, after all,
State-
not a quarreling Miller,
Just-
quarreling
just because
litigant.
State may be there before the Honorable Supreme Court also. That does not mean that all the forums have to be let gone and they have to apply before that forum.
But
They
I
are-
wonder
they are
how can
remedy-
Miller state
Is
even
that
oppose this
discussion
prayer?
to ask Mr. Bandyopadhyay whether we will entertain or yes.
So, Miller, we say that, Miller, we may be given appointment following the roster, Miller, be it 75, 25, 50, 50 at
roster
time
for
frame, and Miller appointment in terms of the roster. That
All right. The learned advocate appearing.
In division bench order not to cross 1729, but they have fill up only 409. They have complied the order, that is wrong. The division bench order said not to cross the 1729,
401 is
but
less than-
409 only fill up from the promoter.
Yes. Otherwise,
This is
we will cross
clarification, but
52.
he has
That will
saying
jeopardize.
the single bench order complied.
16776.
Once the division bench was pleased to direct not to cross 1729,
Election
but
law
only fill up
402.
409 from the promotee, not fill up 1729. My learned friend is
No,
submit.
1529 has been
Direct.
appointed from direct.
That is what they are saying. They have complied the single bench order. That is wrong. Division bench also saying the order by directing not to fill up one.
That's very good. That issue becomes that is a incidental issue.
But
When we are deciding the matter,
yes,
you will get
but
the result from the judgment.
Compliance. But it is
He
not-
says he complied, you say you not
No,
complied.
that's my learned friend has not heard me, my lord. I have said I have complied with the interim order in the appeal, not with the.
No, my lord, one thing, after filing the writ petition, they choose to file a appeal. This is the wrong, right? Several writ petition is pending. This for implementation of the single bench order. After that, they have filed that
Implementation of the
of the order of the largest single bench.
yes.
But after that, they filed the appeal, and the appeal court, they have directed not to cross.
I don't understand you, sir. The writ petition disposed of. Against that, they have come up in appeal.
But may I clarify? There is a good number of promotees. Now, some of them initially came, they were successful. Now, when they became successful, what happens that out of the promotees also, my lord, certain criteria have to be fulfilled, like 10 years service, and they are successful in the examination. Now, who are the writ petitioners? Some of them might not have fulfilled all. So maybe they had a little vigor in continuing with the appeal. So other promotees came, filed an applications, and all were added. They stepped into the shoes of the writ petitioner itself. So thereafter, since the number of the promotees are more, and since the single judge's order was not complied with, several writ petitions also filed so that this 50-50 is followed, complied
So
with.
many writ petitions.
Yes,
still
once
pending.
lordship decides, so it will govern that. That's why I said that once the fundamental point is decided, everything is decided.
বুঝতে পেরেছেন কোথায় গেল কার্তিক? এই ইন্ট্রিম অর্ডার
ইন্টারিম অর্ডারটা কত তারিখে গো? ইন্টারিম অর্ডারটা কত তারিখে ছিল?
না না, যেটি রিচিং অর্ডার পাস
Please, 11th July.
জেরক্স করে দুজনকে দুটো দিয়ে দিন, জেরক্স করে কতক্ষণ লাগবে? আমরা হ্যাঁ, ঠিক আছে, তাহলে দুটো এখানে।
Interim order was of 11th July.
হ্যাঁ, 11 জুলাই বার করে এখানে একটা আর ওখানে একটা দিলেই ভালো হয়। হ্যাঁ, আর ওরা বলেছে, হ্যাঁ,
Interim order followed, my lord, 1729 for both. That you can go up to 1729 for promotees, for direct recruitees. That was the interim order. Because that's also 50.
We did not go to that extent because our notification was 422. So we did not exceed 422. We did not want to get into that situation where we had to remove them.
Before taking decision, kindly, since it is a government appeal, state government appeal, kindly page 49.
What you are
Page
saying?
49, because it should be clarified, because kindly see the date and
How many? Don't argue by installments,
kindly
sir.
see the page 49 once. Kindly see page 49 of their appeal.
So why didn't you say when you were arguing?
49 কি আছে?
509টা।
কি এটা?
মেমোটা দিচ্ছ কেন? আর ইনিশিয়াল কি করে how the relevance of this letter?
Mailman has approved.
Page
49.
40?
49. The date is given 20th December 2018. But decision is first line. I am directed to inform you the 55th meeting cabinet held on 21st February 19.
I think it's a typo.
typographical mistake.
I think
My learned friends' defense in the appeal turns on that, I have nothing to say.
It is your appeal.
Yes,
that must be type. It's
if you
nothing.
can get the appeal dismissed because of that, I have nothing to say.
What
Well,
you
let
are
us
saying, sir?
concentrate on
What you are saying, Page?
the point কি আপনার?
At a point about it is also a part of the Anganwadi.
What is the wrong in this?
The date is wrong.
The date, it is the wrong one. The memo is the correct different.
What should
Memo is
be the
different.
date? What should be?
Since they are the appellant, say they should clarify it. What is the why it has been written?
এটা কোনো point না, ছাড়ুন না. There are fundamental. Well, Lordship is concerned with more fundamental points. এটা ছাড়ুন.
আমি যেটুকু
আপনি এই অর্ডারটা
It is on record.
আরে সে তো পুরো হাইকোর্টই অন রেকর্ড, কোর্ট অফ রেকর্ড, তোমার সাবমিশনের রেকর্ডে চলে যাবে।
Give me the advantage. You will get the advantage.
No, of course he should. Why not? All lawyers we are meant for that.
এইটার পেপার বুক কার্তিকের শোনা।
You get
493 ইয়েটা কোথায়? ওইখানে আছে, তারা দেখি তো। আর ক্যান অ্যাপ্লিকেশন 6 and 7 ওয়েট করো দেখি। দুটো ফাইলের থেকে ক্যান অ্যাপ্লিকেশন দুটো। Except CAN 6 and 7, is there any other application?
From my end, there is.
No, from no one. All others have been disposed of accordingly.
All were allowed before.
Excepting mine,
Yes,
all
because
are.
his point was different.
So Mr. Banerjee stands on a unique position.
As usual. The worst sufferers are which men?
Was suffer is a state who is not able to fill up the posts.
পিছনে টাকা দিয়ে গেছে, টাকার পেছনে কোথায় অর্ডারটা দিয়েছে? Yes, to the learned advocates appearing for the respective parties have concluded their arguments. That's what it said. এটাকে তোমার এটাকে এটা কি না না এফিডেভিট দুটো বের করো। State has filed two affidavits.
But,
That affidavit,
the additional affidavit only in one matter. And that matter affidavit.
Kavita.
But if in the can.
no, you the report which was that has been annexed to the
Paper book, Malad, that additional report is not there. Malad,
Achha.
that as directed by the coordinate bench, Malad, that has been filed separately.
What is, when did you file it?
লাস্ট অর্ডার হয়েছে না সবই আমরা ফাইল করে দিয়েছি না অর্ডার হয়েছে অর্ডার আছে তো কাছে হ্যাঁ আছে আছে
পেয়েছেন এফিডেভিটটা?
পেয়েছি
না না না
অর্ডার যে এক্সেপশন এক্সেপশন আগে ঠিক আছে হ্যাঁ ভালো অর্ডার
this is the one you filed. আচ্ছা
Only
এইটা
in one matter.
হ্যাঁ
Only in one matter.
এইটার আরেকটা কপি তো থাকবে।
এক্সেপশন অলসো আমার ওটাই
আর মেইন ফাইলটা ওখানে আছে তো? ইয়েস থ্যাংক ইউ।
ডিপলি অবলাইজ
হ্যাঁ বলে দিচ্ছি। Please, any one of you take the responsibility of putting your appearances with all the applicants, etc., etc., because we face this difficulty. Please, any one of you take the responsibility to give a list of the advocates applicant.
নাম বলে না
এই আগের দিনে যে অ্যাপিয়ারেন্স ছিল ঠিকই তো আছে তাহলে ঠিক আছে
একসাথে বসে প্যারাটা এগ্রি করতে হবে ওটা।